And now, it is my pleasure to introduce our opening speaker, James Sheehan, to the podium. Jim is the Charities Bureau Chief at the Office of the New York State Attorney General. His bio is in your kit. And with that, James Sheehan.
Thank you, Claire. Appreciate it. Thank you very much. My colleague, Karen Kunstler-Goldman, is here in the front row, as she's always in the front row. After 37 years working in the Charities Bureau, she is the institutional guiding spirit for our entire organization. I should tell you, one of the things she has the power to do is to make you influential. And the way you become influential is to give her your business card and you end up on our email list on a monthly basis. So all the new stuff that we do, she will make sure that you get it. So at break or some other time, let us know and give us your business card. We'll put you on the list. Let's start off with our new Attorney General, Tish James, who took office on January 1st. We're very excited to have her, and she's been very much a supporter of the Charities Bureau and the Charities mission. You're going to hear more about her in the next year in this space, but we're very pleased and very much appreciative of the support that she's given us in the first 2 months. Oops, there we go. Okay, so I've got Luana is a taskmaster, and she said you have 20 minutes to speak, 10 minutes to take questions, and then you're off the stage with a hook. So I want to make sure that I get through the topics we want to cover. First one is looking at the Attorney General. One of the things that's happened in the last couple of years is the IRS resources to oversee nonprofit and exempt organizations are down by about 27%. And they basically have given up. They have reduced their footprint, I guess is the proper term, on overseeing the nonprofit world. And what has happened is that the Attorneys General as a group who stepped up to address these issues. And so I guess the last slide, it's nonpartisan. It's intentional failures of federal regulation because that was one of the objectives the president articulated. But I think what's happened is you'll see is that the state attorneys general now have a much greater role than they did even 2 years ago. So I want to talk about a couple things today. I'm going to talk about political activity. I'm going to talk about a couple of our enforcement cases. Then I'm going to talk about sexual harassment and sexual abuse, which has become a major, major issue in the sector and with us in the last year. So first, none of this comes as a surprise to this audience. What's prohibited? You can't participate or intervene in a political campaign. You can't contribute to political campaign funds. You can't make public statements of position for the organization for a political candidate. Now, it will, nonpartisan. One of our issues is making sure that charities in New York follow those rules, right? And the statutory authority is you can't engage in a violation of public policy as a charity, consistent and ongoing. So this is a check from, you'll see on the bottom it says, I can't read it from here, but Puppy Jake is essentially a charity that provides dogs for veterans, and probably is a very worthy charity. The issue is that Mr. Trump, in his during the Iowa primary, he stepped up. He had a campaign to raise funds, and on the one hand, it said "Make America Great Again," the Trump campaign, and the other side of the stage was Trump Foundation donate. So if you go back to my last slide, you'll see you can't do that. All right. So what we ended up doing was bringing a case against the Trump Foundation to dissolve it. And one of the issues that arose with the Trump Foundation, they had no conflicts policy, they had no annual disclosures, they had no related party approvals, they had no independent board, and what we did was we charged them with waste and related party transaction violations. So we just had a decision from the New York Supreme Court saying that these claims can be asserted. They're valid under the not-for-profit corporation law, and we are now scheduled for a decision on the merits of the materials we filed. But I think two important things about the Trump Foundation. One is the engagement in political campaigns, which is an absolute no-no and can be enforced by the states as well as by the federal government. And the second is making sure that you have a system and process for complying with the amendments to the not-for-profit corporation law, including related party transactions, conflict of interest, independent directors, and appropriate oversight. And these are not concepts that are new to anybody in this room, but it's important to understand that they apply to the mighty and the non-mighty alike. The second case that we did this year is the Edmund Brady and the Breast Cancer Survivors Fund. So the Breast Cancer Survivors Fund was basically a tool of a fundraiser, and he got about 92% of the total funds that were raised by the organization, and the rest went for salaries and accounting expenses and things like that. So the key, one of the things that we require in New York that many states don't require is audits. And that the audit requirement is pretty specific depending on your dollars. And the idea is that auditors are independent. They have a responsibility to the organization, responsibility to the public. And so we charged Mr. Brady in a complaint we filed in April with disregarding basic professional standards for auditors and failing to report significant internal control failures. We got this case in part because there were two junior auditors working with Mr. Brady. And they came to him and they said, you know, we have not talked to a single officer of the Breast Cancer Survivors Fund in doing our audit. We need to talk to an officer. The only person we talked to is the fundraiser. And his response was, if you don't want to work on this project, we have other projects for you to work on. But the professional standards of auditors are an important part of the protection for the public and for the charitable mission. And so the BCSF was dissolved. Mr. Brady will not be doing audits in New York anymore. He agreed to that as part of the judgment. Next issue, bad things happen to good people. Now this is a tough issue for me. I was raised Catholic and I still have some allegiance to the church, but in September, we were given the responsibility of investigating the 8 dioceses in New York for sexual abuse. And the sexual abuse investigations are painful. They involve very private matters. And what we're finding out is, if you look at Charities, they have responded, and many of them responded no better than for-profit organizations to these kinds of allegations. If you look back to the Weinstein case, that was a for-profit organization. But when I look at the Catholic Church and how long it has taken them to recognize the severity of the problem and to address it, and then I look at some other charities, which we'll talk about, one of the concerns that we have, what is the responsibility of a board of directors faced with allegations of sexual abuse? And the lawyers will tell you, not all lawyers, but some lawyers will tell you, you have to focus on defense, right? You have to focus on how much money will we lose if these allegations turn out to be true and are proven. And my suggestion to you today is you have to think much more broadly as an organization about your mission, your values, and I guess outcomes, Dean Birdsall. What are you going to do to protect the mission of the organization and your responsibility to the charitable beneficiaries of the organization and to the other stakeholders that you have? And this is a major leap for some lawyers, right? Because the temptation is to say, defense, 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 attorney-client privilege, everything's a secret, we're not going to tell anybody, and we're going to fight on the battlefields and go against the victims. To me, as a nonprofit, that's not the appropriate response. So responding to victims, timely process. Next question, should you promise a thorough and independent investigation? All right. The worst thing, by the way, that you can do is promise a thorough and independent investigation and then not follow through. And I will tell you, and cooperation and not follow through. So my suggestion is if you face, as an organization, these kinds of problems, you take a look at 2 reports that have come out in the last 2 years. One is the Emma Willard School in Troy, and Cozen and O'Connor did a report, about a 250-page report, which is very thorough, very thoughtful about the history of sexual abuse at Emma Willard, what happened, what the responses were, and what the school is doing now to address it. Very, very tough decision to make to invite the investigators in to look at the report and for the board to approve it. And my general rule is bad things happen to good people in the nonprofit sector, and the issue is how you respond to those things that demonstrates your quality and your values. The next one is the Ropes and Gray U.S. Olympic Committee report. This report came out in December, and if you remember Dr. Larry Nassar at Michigan State, Michigan State had a huge problem, but the U.S. Olympic Committee and U.S. Gymnastics had the same problem because this was all going on in the reports to the organization at the time about what Dr. Nassar was doing. And so the most important part of the Ropes and Gray report, which is excellent and worth reading, is the discussion of independence, right? What is an independent investigator, and what are their responsibilities? And U.S. Olympic Committee and U.S. Gymnastics made a commitment from the get-go that they're going to have an independent investigator. They were not going to tell them what to find, and they're going to issue the report. If you're sitting on a board or you're an executive director, this is a very painful process, and it requires judgment and tact and sensitivity and a thought about what the impact is on the organization. And very often the organization itself is at risk. But again, in the nonprofit sector, part of our responsibility is to mission and to the beneficiaries of the charity. So those two reports, if you find your organization in trouble, these are reports to read, not necessarily because you're going to adopt everything they did, but understand that transparency approach to the problem. So then we have those are the how to do it. So then we have the how not to do it. The University of Southern California had Dr. Tyndall, and we'll show you a picture of him next. He was allowed to resign with a payout in 2017 without informing his patients or reporting him to the Medical Board of California. And you'll see in a second what he did. Michigan State, they did exactly what I said you shouldn't do. They said we're going to have an independent investigation by Pat Fitzgerald, former U.S. attorney, and will lead to prompt and appropriate action in response to what we learned. Attorney General of Michigan said, okay, so tell me what he found and what your prompt and appropriate action is. And they said, they prepared no written report of any findings, and they said to the Attorney General, he was not hired to investigate for the purposes of presenting his findings to the public, as MSU originally implied, but to prepare and protect the institution in forthcoming litigation. Exactly wrong. So this is Dr. Tyndall. And again, if you think about how universities work, one of the temptations is if somebody does really bad stuff and you have some information about it, and the choice is between letting it be public and litigating it or letting him go and paying him off, the temptation is to pay him off and to let it go quietly. In this case, the allegation was Dr. Tyndall was a gynecologist with the University Health Service, was sexually abusing numerous students who came to the clinic. And at USC, there's a significant population of people from overseas, not familiar with the American medical system, not familiar necessarily with how to complain. People did complain, and they complained over a period of 10 years. Not a million, a small number, and the clinic kept him on. And then he insisted on a payout in order to leave, and they gave him a payout. So this issue is not just confined to the Catholic Church or USC. So this is a list of some of the organizations who have faced similar problems. Catholic Church, Southern Baptist last week, Southern California we've talked about, Michigan State we've talked about, Columbia, another gynecologist with Columbia Presbyterian, forfeited his license, and there's a lawsuit filed against Columbian Presbyterian, again, looking at how do organizations respond to these issues. And the temptation, and believe me, the lawyers are part of it, is to say, let's not talk about this, let's make it go away quietly. And sometimes you'll talk to your insurer, and they'll say, you have to cooperate in the defense, which means you can't tell anybody anything about what actually happened. And I'm going to suggest to you that's the wrong answer. Okay. So that's the larger picture of how do you respond. But we look now at the law, how the law has changed in New York in the last few years. So 2015 amendments to the Human Rights Law. Every employee is entitled to a working environment free from sexual harassment, and they're now talking about changing the law even further in the favor of the victims. There's a guidance document from the Division of Human Rights. And essentially, what has happened in New York, we go from plaintiff, you have to prove pervasive and thorough sexual harassment to you got to have a policy, all right? You got to have a policy in your organization, and here's what it has to include. It's a cookbook, right? Examples of prohibited conduct, governing law, complaint form, et cetera, and you have to get them training by October of this year. These are not complicated issues, and they should not be complicated issues for a nonprofit, and it's the kind of thing that you can include as part of your compliance training. So one of the issues that we face in the nonprofit world is volunteers. How does the sexual harassment law and policy apply to volunteers? Because many, as we know from the Catholic Church, in many cases, the volunteers are both exposed and present problems for the organization just as much as employees. One federal judge says it applies, some don't. My strong suggestion is that you give the same training to your volunteers that you give to your paid employees. So then we go from what's required to best practices. Anonymous complaints. I think you absolutely have to have that. Mandatory reporting for supervisors and managers. We see all the time that someone will come to a manager to complain and say, this is what happened, I was sexually harassed. And the manager says, well, do you want me to report it? And if the answer is no, they don't report it. What we found is it makes sense to take away the discretion from the manager because we have a responsibility to make sure that it's a workplace free of sexual harassment. Designated managerial recipient for reporting. Who wears the hat? Who's got the responsibility? Not just the direct line manager. Who else has the responsibility? Independent investigation process. We talked about that already. Periodic reporting of complaints and outcomes to the governing board. And disciplinary and remedial action, including reporting to employees. Do not do what USC did, right? Let this guy go, pay him a farewell bonus, and pretend it never happened. This is another demonstration of how not to do sexual harassment investigation response. This is Michigan State President Engler in January. There are a lot of people who are touched by this, survivors who have not been in the spotlight. In some ways, they've been able to deal with this better than the ones who have been in the spotlight who are still enjoying that moment at times, the awards and recognition. I think this is the Sheehan Goldman Award for Cluelessness is this quote, right? The awards and recognition. If you talk to survivors of sexual abuse and sexual harassment, and we've done that, it is painful to read. It is painful to read the complaints of sexual abuse. It's painful to talk to the survivors. It's hard not to cry with them. Well, never mind. Next. This is Mr. Engler. 2 days later, the board fired him. So they did something right at Michigan State. So sensitivity to victims is a hard thing to do and a hard thing to do right. But it's very important for your organization, for the mission of Charities, that's what happens. So next piece is whistleblowers, right? And sexual harassment victims who complain are whistleblowers. And one of the things that I've seen managers who have a goal of 0 complaints in their work plan for whistleblowing or complaints. 0 is a bad number. I think people have heard me say that before. So 0 is a bad number. One of the things that you learn about whistleblower processes and anonymous complaint processes, they're a sign of a healthy organization. Navex Global did the study. The functioning internal hotlines are of paramount importance in making the organization work. And it's a hard thing, right? If you have a hotline, 75% of the stuff on the hotline will be complaints about personnel issues. And you'll say, well, what good does that do? What it does is it gives people a place to be heard. It gives them respect that we're taking their complaints seriously. And if you look at the research, process in many ways is much more important than outcome. Making people believe that their complaints are being paid attention to, even if they're eventually not found to be valid. So, how am I doing, Luana? 20 minutes, okay. So remember Karen has her list of influential people in the New York Charities community. We're very proud of our website. 2 new additions this year. One is as to audits and the proper function of an audit committee. That came out in September. And the second product that we put out this year is the sale of nonprofit nursing homes. And this is significant because what we've been seeing in New York is about 5% of nonprofit nursing homes are sold to for-profit entities every year in the state. And we looked at the research, and as it turns out, in general, nonprofit nursing homes do a much better job of taking care of patients and have higher levels of patient satisfaction than for-profits. So the guidance says if you are a board and you decided you can't continue as an independent or nonprofit chain, here are the things you have to think about. Who's buying? What is their track record in taking care of patients? What commitments will they make to you to make sure that the quality of care will continue? And don't just hire an investment banker to maximize the price and then put the director of the nursing home in charge as the grant maker. This issue, and we didn't make this up ourselves. We reached out to the sector for best practices. But I think if you look at sales and changes in ownership, this kind of business process is really important to do it right for your mission, for your organization, and for your beneficiaries. And with that, we have 10 minutes for questions.
We do. And I just want to invite everyone to write questions in your question cards. Our staff will come around and take your cards. I do have a question here for you. It says, can you tell us what changes are in place as a consequence of the 2018 tax law? I'm not sure that would affect you guys.
Okay, so the 2018 tax law has been a real challenge, and it's a challenge on a variety of fronts. One is 90% of Americans will not be filing itemized returns. There's the bizarre tax on transportation, which I don't understand. I don't understand how you comply with it. So I get, reality is we hate it. I'm sorry, nonpartisan. We recognize Congress' ability to pass laws. We think that these laws have significant impact on the charitable community. One of the good things that behind the scenes, we talk to people about the 22% tax rate for certain kinds of activities at charities, and the New York legislature just passed change to make sure that the add-on tax for the state was not applied. But I don't like them, but that's not much I can do about it.
Okay, next question. How do you balance the need to prosecute and the right to privacy?
Okay, so the right to prosecute.
The need to prosecute
Need to prosecute.
and the right to privacy.
Right, so one of the issues that we face on a regular basis is in what context should we make public investigations? And so the policy we've adopted is, if you think of the Attorney General's office in terms of charities, there are 5 stages of review. So there is what a registration unit does as a matter of course, right? They look at the filings that you submit every year or the initial registration and say, here there are deficiencies we note in your filing. Here's a letter, please fix it. All right, or you haven't filed, please file. All right, and that's a relatively ministerial act, right? The statute says you have to do it, it's not done. The second, and that's public. If you submit a FOIL request for other people's letters, you will get those, right? And so that's not a privacy right. You have an obligation to file. People can look and see if you did file, and if we send a letter, that's where we are. The second issue is inquiry. So we get a complaint, we get a press report, we get a letter from an elected person, we get something else that says you should take a look at this organization, bad stuff is happening. And in that case, we may make public the fact of the inquiry, right? So we'll send a letter saying, we've received a complaint about X, can you send us these things in response, usually documents. That's a judgment whether we disclose it. Often we will talk to the organization and say, we got this letter, what do you do next? What's your response? Because this will shock you. Just as 75% of the complaints that come in on your hotline are personnel matters, 50% of the complaints that come into our complaint area, which Karen oversees, are human problems, not legal problems. And board members disagree. Somebody didn't do something that they're pissed off about what happened 10 years ago. So we don't want to expose that organization, which is a charity, which has a charitable mission, at this stage, except to say we've received an inquiry, we're responding to it. Or we initiate an inquiry, but that's where we are. The next stage is investigation. An investigation requires a determination by the Deputy Attorney General that we should open a file and investigate this organization. You will not see from this administration, I believe, a statement that we've opened an investigation, right? The law does not say we can't do that. My belief is it's fairer to organizations in terms of privacy to do the investigation first, to come to conclusion as an office as to what should happen, and if we have a plan to file something, whether it's a complaint or a petition or a AOD, agreed upon settlement, or a letter resolution, that can be public because the organization and the people involved have the opportunity to respond in a court proceeding or in deciding to settle or not. So the key issue, I think, is we take lots of depositions in our investigations, we obtain lots of documents, I think the fair practice is not to go public with the details of investigation while you're doing it, but to wait till you come to a conclusion as an office. And that's the privacy protection.
Okay, we have a lot of really wonderful questions here, and I'm not sure we'll get to them all. So let's start with one about unreasonable related party transactions. With a decrease in enforcement actions by the IRS, who can impose penalties legally available for unreasonable related party transactions and loans to officers?
Okay. There's only one organization in New York which has the power to impose penalties for unreasonable, unrelated party transactions, and that is the Attorney General's office seeking it through the courts.
Okay. What are effective remedies when senior officials try to make problems go away?
Are we talking about Michigan State or at USC? So one of the things we believe, part of the issue is what's the discretion of the organization's board to address these issues. And the organization may make a judgment about, as between defense and transparency, we're going to lean toward defense. And within a certain level, that's a discretionary decision. I may think it's a bad decision, but it's not an illegal decision. To me, just as we did in the slide on whistleblower remedies, the first remedy is internal. And the tough part of this is people have to be courageous enough first to raise the issue directly with the officer who's doing this. And the second is to think about what other resources you have. And that may be board members, it may be the general counsel, it may be the compliance officer. But to raise those issues, and then to get advice before you decide whether you're going to go beyond that.
Okay, there are a couple of related questions from smaller charities. One is, our board of directors are volunteers, so what is our best practice to provide sexual harassment compliance training for them? And then related to that, smaller charities struggle to meet our payroll. There are a lot of regulations. We can't afford to provide an independent investigator. What would you advise us to do?
Okay, so for smaller charities, so the first issue is, do you train board members since they're volunteers? And the answer is absolutely yes. They need to know not just what they should do, they need to know what the organization is going to do in addressing these issues proactively and then responding to them. And then the second issue is we can't afford independent investigators. And that's true of a lot of organizations. So my suggestion is that you have an independent board committee, so these will be independent directors who will have the responsibility for overseeing the investigation. And again, you can go back to the Ropes and Gray process, in which they set up an independent committee. It's not perfect, but it's given the economic limitations, you want people who are independent and have no stake in the outcome personally. They have a stake in the institutional outcome, but not personally.
Okay, one more. If a nonprofit receives funds from the government, is that considered lobbying? There is a rumor that there's a bill that says if a nonprofit accepts funds from any politician or government agency above $500, the organization must register as a lobbying agency.
Okay, so that's really two very big questions in a very short time. So the first thing is, it is not illegal for a charity to lobby, right? The distinction is between political campaigning for a candidate for office or against a candidate for office. You cannot do that. Lobbying, can you go up to Albany? I live in Albany, and on Tuesdays, it's lobby day. And it's, in some ways, it's a wonderful thing because New Yorkers believe that you can show up at the legislature in a large group and talk to your legislators directly, and they'll actually listen to you. And they do. And whenever I get frustrated about government, I watch this process, and there are 1,000 people lined up to get through the security areas in the Capitol to talk to their legislators and to say, we care about this. So where was I going with that? So that lobbying is perfectly okay, right? And there's a dollar limit on it, and you have to report on your 990. So that, if you think about it, why do some corporations get these huge benefits from the public, from the fisc, and charities are fighting to get their 10% administrative costs paid within the same year that they incurred the costs? And the answer is that they can make contributions and you can't. So that's the law. But the flip side of that is that you have to think about what you're allowed to do and how you can advocate. And in many ways, charities have an extremely effective grassroots support, and elected people listen to that. So the second part is the registered lobbyist stuff, and I've seen that fight in Congress, and I don't fully understand it yet, so I'm going to duck it.
And that seems like a great place to stop. Thank you so much to Jim Sheehan.
Thank you very much.
Thank you, Chief Sheehan. Once again, excellent presentation with important information for all of us to know.